Navigating the Complexities of Special Education Discipline, Shortened Day, and Child Find, Where They Intersect, with Nancy Goosen, OSDE Policies and Procedures Program Manager, February 19th, 2025, Cirque's Wisdom Wednesday webinar series.
Hi, I'm Dr. Allison Conch. I'm the Assistant Director of Special Education Resolution Center. Thank you to those of you that are joining us live today, and appreciate those of you watching this recording. We are privileged to have Nancy Goosen with us, who's with the Oklahoma State Department of Education, Special Education Services. She is the Program Manager over Policies and Procedures. So she is here to talk to us today about discipline, shortened day, and child find. These are issues that we get lots and lots of calls about, and I'm sure the SDE does as well. So Nancy, thank you so much for being here with us today and presenting on these topics. I will jump in and kind of intersperse with questions to clarify based upon calls and questions we get. And then we'll have time at the end in case any attendees have questions for you as well. So take it away, Nancy.
I appreciate it. Thank you, Allison, and help me with the chat because I can't see that with the way I have my slide deck up. So I appreciate your help. So I labeled the presentation today, Navigating the Complexities of Special Education. So that's what I hear a lot from parents, including school districts, that the special ed law is so complex. But also that's the wonderful thing about the special education law, is because it is complex for a purpose. And so to start off, I want everybody to understand that complexity is because of the fact that our students with disabilities are so unique and different. No matter their category of disability, the law talks to us about the fact, including we had a Supreme Court case through Andrew F, being that we must look at children based on their unique needs and unique circumstances. And a lot of people thought that was a coin phrase of unique circumstances, but that's been in the law a long time. So when you look at discipline of students with disabilities, what does the federal IDA regulations say about it? Well, it starts in 300.530 is really a great place to start reading. And it talks about the fact that it's a case-by-case determination. That school personnel, they have the authority when it comes to disciplining students, both students who are non-disabled and students with disabilities. And with students with disability, we have to look at those unique circumstances and determine it based upon whether there's a change in placement consistent with other requirements within the law and is appropriate for the child with a disability who violates a code of conduct. So in other words, when people ask me a question, I always say it depends.
And Nancy, we get a lot of calls from principals or superintendents if it's a smaller district who, when it's related to discipline, of course, the administration they're the ones responsible for those disciplinary things. And then the IEP team comes in later. I know you're going to get there. And that in that federal reg, because it says case by case basis, that allows principals or leaders who would be enacting disciplinary removals to not necessarily have to stay in line with that code of conduct handbook, correct? Like they could make a different decision for a student with a disability based upon their knowledge of that student. They don't necessarily have to, like, oh, this happened, so I must follow this handbook exactly. That allows them that freedom. Is that correct?
Correct. In that you would never want to, provide a discipline that would be greater than a student without a disability.
Right.
But you could go a lot less than what would be typical of the number of days for suspension of a particular incident. So that is correct. You look at their unique circumstances, you look at the disability related characteristics of the child to make that determination as an administrator. Hence why it's so important for all administrators to be involved in the understanding of the federal regulations. The other thing I want to point out is that it is an administrative decision. I have heard of situations where a special ed teacher or gen ed teacher would send a child home without administration being involved, and that's a breach of statute, including Oklahoma statute. So it has to be an administrator that would ever send a child home, even during the school day. But yes, you're correct. So When it talks about a change in placement, what does that mean? And so we look to the statute to say, what does it mean when it talks about a change in placement? Well, that means when we do a removal of a child with a disability from their current placement, and that includes their special education services. So anytime there's a change in placement, when it comes to discipline, there is this 10-day rule, and it's 10 school days, by the way. It is either one, a removal that's more than 10 consecutive days. So again, we're looking at anything that's at 10 days or less versus more than 10 days. So starting on the 11th day. Or the child has been subject to a series of removal that constitutes a pattern. And because a series of removals total more than 10 school days in that school year, it can be cumulative. So then you look at, what does it mean by constitutes a pattern? Well, looking at the statute in 300.536, a series of removal constitutes that pattern because of the student's behavior is substantially similar. So, you know, what type of incidents are happening? Is it fighting and physical aggression? Those are becoming similar types of situations, including when we're looking at a pattern, we want to look at the length of those removals, how long each removal is lasting, as well as the total amount of time. So that's that cumulative, we're adding it up. And then the proximity of those removals, is it a short proximity or are they spread out over time? So we're looking at this pattern. So again, we're looking at those 10 consecutive days versus these 10 cumulative days. So talking about suspension, what about in-school suspension? Can I just put a child in school suspension down the hallway and does not count? Well, there's the answer. It comes out again. It depends, all right? So typically in-school suspension can count toward those 10 days unless these three things are met, and all three have to be met. One, the child's afforded the opportunity to continue to participate in their general education curriculum assignments. Two, they still receive all their IEP services. So like if I have speech as a related service, I get to leave and go down to see my speech pathologist for my speech therapy. Three, they continue to participate with non-disabled children to the extent they would in their current placement. That's the one that tends to get administrators. I've seen this happen a lot, especially in elementary school. They'll have the little kiddo that has a disability come down to their office and they put him in a cubby or maybe even in their office. And they give them their general education assignments. They'll actually escort them down for their speech therapy, but they're missing this third one, meaning that they must participate with non-disabled children. And if they're not, then those days in that cubby, those days in that principal's office, they do count toward those 10 days. So you need to be aware of that. What is an informal removal? Well, technically, informal removals were not defined in IDA back in the early years, nor in the amendment, but we're seeing more of this since the pandemic. And so the U.S. Department of Education, Office of Special Education and Rehabilitative Services decided to put out some information and address this through a Q&A. And they talked about the fact that informal removals mean actions taken by school personnel in response to a child's behavior, which excludes the child for part of the day, or sometimes it's all of the day. And sometimes it's even for indefinite periods of time. And so I first want to talk about, before I start giving you some examples of informal removals, I want to talk about this part of the day or all the day. Let's talk about, what does the law talk about when it comes to what is the definition of school day? So in 300.11c, it defines it for us. So school day means any day, including partial day. So if I suspend a child for half of a day and send them home, that half day counts toward those 10 days. So you need to keep track of your half days. And a school day has the same meaning for all children in school, including children with and without disabilities. So for example, today it's icy out. Some of you closed down schools. So if school's closed today, it's closed for everybody. So today is not a school day, right? But if we said, okay, school is going to be virtual today. If I say that, that day counts. So if that kiddo is on a suspension day, today would count because we're counting virtual as a school day, even though everybody went online, that would count as one of the days of suspension. So,
Amy,
yeah.
question in the Q&A related to the in-school suspension, that third criteria that you mentioned, ability to participate with non-disabled peers. If there are other students in the in-school suspension that are without disabilities, would that be counted or included as, okay, they're still participating with non-disabled?
Yeah, at number 3, if you have the child in a room with other non-disabled children, and they're still able to get their IP services and still get their general education curriculum, then the in-school suspension would not count toward those 10 days.
But if the other kids in school with them are also IEP students, it would be almost the same as if they were there on their own. They're not participating with those non-disabled peers, right?
Correct. I'm sorry, I didn't hear you. Yeah, if those other students are only students with disabilities on IEPs, then no. It has to be, it's very clear, it has to be children who are non-disabled in the same room with them. Otherwise, it will count toward their 10 days.
Thank you.
Good question. Okay, so because I still want to talk about day, we talked about the definition of day. So partial days do count. And depending on the definition for all students, that's also a day in school. And so those days also count. So let's talk about the use of shortened day. So before deciding to shorten a student's day, the IEP team, this is a really serious matter, because if every other student who's non-disabled goes for 6 hours a day or however many hours a day for what we call a full day, and you're going to shorten it or anything less than what anybody else would get, that's very serious. And it requires the team to get together and discuss what are some other ways we can meet this child's needs to help the child get through a full day, be it behavior or medical. Maybe they need to take short rest breaks. Maybe they need to have support of a school nurse, whatever it might be. We need to do everything possible to keep this child in school a full day. Now, when we determine that, you know what, we've tried everything we possibly can, and now we've got to go to a shortened day, then the team has to sit down and explain why that the student's disability-related needs require a shortened day. And oftentimes a parent may have a child who has severe medical condition, and they bring in something from the physician saying that they're going to have this treatment for so many days, and it's going to make them so fatigued that they're not going to be able to come to school, long as they have some kind of documentation to support that. And then there needs to be a plan for returning the child back to school full-time, including the frequency of the student data and determining how we're going to return the child to full-time, and really clear explanations of how that's going to work and the goal to make that achievable. So this is really only supposed to be a limited amount of time, and including, we have an Oklahoma policy that says if you're going to do shortened day based on behavior, you must have minimum a functional behavior assessment and a behavior intervention plan. And so there should be some evidence that the team has taken the child's behavior very seriously, conducted a formal functional behavior assessment to determine the function, creating a hypothesis of what is the function of this behavior. And then from there, creating a really formalized behavior intervention plan and implementing that behavior intervention plan to see how to reduce the maladaptive behavior. So that has to be in place. That's not an IDA statute, but that's an Oklahoma policy for special education.
And Nancy, how do you, I guess this would be your opinion, but maybe there's some other things to back this up too, but you're an expert in this area with the policies for the state and federal regs. For students who might have behavioral difficulties related to, say, a mental health diagnosis, and they're medicated for psychiatric type issues, right? But it's really their behavior might be related to those medical things that's preventing them potentially from staying at school a full day. Schools should still indicate that as a shortened day due to behavior, not saying it's a medical need, correct?
Yes, I mean, it is when a child has psychiatric needs that are so severe that require medication, that sometimes students could be inpatient.
Yes.
And out of inpatient, the psychiatrist who's providing the medication and treatment of this child. So I always say it depends. There may be something from that psychiatrist who says, I am recommending a shortened day and a slow integration back. So all that has to be considered. So nothing's cut and dry when it comes to students. Remember, we have to do it based on our unique circumstances and unique needs. So we can't just say we do this for all kids. So depending on those circumstances, that may change my view of how the team would go about doing this. But if a child has emotional disturbance, that truly is disability related, and we wouldn't want to shorten their day unless we have a lot of evidence of how we've tried to treat this student through, providing direct instruction for social skills, providing direct instruction for self-regulation. Maybe we even have the child's behaviors are so severe that they need counseling, and we have data to support that related service supports. And we tried all these things, and the child's still not successful. Again, that should be the last resort, is shortening a student, especially a student that has an emotional disturbance. That should be the very last thing that we do, because going home doesn't help the child get better. The parent struggles too, by the way. And so and the child who goes home and is in front of a computer, the likelihood of them getting online, initiating their own homework is not as great as it would be if they were in person.
Thank you. I think that's really helpful clarifications. I think people conflate it sometimes of if their behavior is related to some sort of medical or mental health needs, that's automatically a medical shortened day. And it's much more nuanced than that, isn't it? So I appreciate you.
So I will continue to say it depends. and please, that's the main thing. If anybody leaves today or learns anything from this webinar, is that children have unique circumstances, unique needs, must be handled on a case-by-case basis, and do not try to say, well, my neighbor down the street, they did XYZ to their child with a disability. How come they're not doing the same for my child with a disability? And the same in the school setting, a teacher in a classroom say, well, they disciplined this child in Miss Smith's class. How come they didn't discipline the child in my class the same way? And it's because they are unique and different and must be handled that way. So we can't compare. We so badly want to compare, but we cannot, because one, those disability related needs are confidential, and we can't share that with the neighbor down the street or the classroom teacher down the hall. So here's some examples of what we mean by, or what the Office of Special Education and Rehabilitative Services mean by informal removals. It's those repeated times when a student is sent home during the instructional day by an administrator. So they might call mom and say, hey mom, Johnny's really struggling today. Why don't you come pick him up? He's just having a bad day. Those are suspension days. Those are days or half days that need to be counted toward the 10 days. Another informal removal is those long-term use of shortened day without an IEP team decision, without a reintegration plan. Again, that's that, I've repeatedly sent him home. He tends to do great in the morning, but his afternoons, he really gets tired. So mom, why don't we just have him just come, just in the morning, you come pick him up. That's a long-term shortened day without an IEP meeting. This one has happened a lot since the pandemic, is this mandatory virtual or remote instruction for a student with a disability without an IEP team decision, without an IEP change. That is a change in placement from going in person to virtual. They will, if an administrator goes, this is a great idea. I love the pandemic. We learned that we can send kids home and they can get all their curriculum at home virtually. But if I say it's because of your behavior, you can't come back in person, and I'm going to send you home with a virtual, like maybe we have a platform using Canvas or some type of platform like that, some learning management system. That's not allowable. That's a suspension because you, one, done it outside of the IEP team, and two, it's mandatory. I can't come back. You're saying, no, I can't. I have to go virtual. And what's even worse is the law, it's under 300 point, I think 324, it talks about that any lack of progress, and that's academic or behavior toward my goals and the general education curriculum. So if you send me home and I don't make any progress doing that, then you're not providing me FAPE. And you haven't had an IEP meeting to determine, is this appropriate? So you're going to get hit on multiple things when you send a child home mandatorily based on their behavior as a means of changing their placement without an IEP and not calling it suspension at all. The other one is mandatory homebound instruction. And again, without an IEP team decision, you're just sending them home with packets. So not necessarily on the computer, but we're going to just send packets home. That's just as bad as virtual. Here's some more examples.
Nancy, how about, and this, I'm bringing this up because this was an issue recently. If a school is saying, well, we're only going to have you go virtual for your gen ed classes. And so it's really not a change of placement because you're still going to have your special ed classes here in person. And the school team unilaterally makes that call. Is that still an informal removal and or a decision outside of the IEP team if it's for the gen ed instruction?
Right. The IEP encompasses the general education placement. So that is a violation not only of the IEP, but also it is a change in placement of the child because the child was in person and now suddenly the child is not. And so you're denying the child the in-person in class. There's a lot of incidental learning that goes on in a classroom setting, and the child is being denied that. And we cannot do that. That's part of the least restrictive environment. There's 300.114 all the way through 300.118. Lots of components involved in the maximum extent appropriate. The child must be educated with students who are non-disabled and only to the point of a severity level should the child be removed. And so that's super important that you don't do things outside of the IEP meeting. So
thank you.
Good question. Some more informal removals is like field trips. I hear this a lot. A child with severe behaviors, they'll prevent the student from going at all, make them stay back, or they'll tell the parent, you know, he can't go or she can't go unless you go and accompany them. Well, you can't do that unless every single kid going on the field trip has to have a parent glued to them. If that's the case, then no problem because students without disabilities have a parent glued to them. That's fine. But if that's the only child because of their disability and it's disability related, you're making me as a parent go on this field trip? Nope, can't do that. The other thing is requiring a student to stay home because the teacher or the paraprofessional is sick that day. You can't do that. You can't call the parent and go, well, his one-on-one, because the kid's behaviors are so severe, you say, well, his parent's sick and so he can't come to school today. He'd have a really bad day if that parent didn't show up. So what you have to do as a district, you've got to figure out how to get somebody there to support. You have a backup plan. When somebody gets sick, be it the special ed teacher, the paraprofessional, whoever's supporting that child's unique behavioral needs, you've got to have a backup plan. That child is allowed to come to school. It doesn't matter if we've got people who are sick. So that would, if you make the child stay home, that would be a suspension. Another one is removing the student from the classroom to the principal's office, which we talked about that one earlier, and not counting it as in-school suspension. So let's talk about a manifestation determination. A lot of people use we love acronyms in special ed. So MDR is the manifestation determination review. And that begins in 300.530. And a manifestation determination has to happen within 10 school days of any decision to change the placement. So what did we talk about earlier? What's a change in placement? Change in placement is when we're going to suspend more than 10 days, so starting on day 11, or cumulative days that add up to being more than 10 days. So in order to have our manifestation, we have another 10 days. So I hear this from parents going, they're going to suspend my child and they want me to meet today and I can't meet today. I've got a neighbor picking him up, but I can meet next week. Is that still okay? And I always say yes, because the law says within 10 school days of the decision to change the placement. So we're making the decision on day 9 or 10 that we're going to go over the cumulative days. So we still have another 10 school days to have this IEP meeting to do this manifestation determination. And again, it is relevant that the team get together because we have a lot of things to review. And the law says we must review all relevant information. So what would be considered relevant information? Well, the student's evaluation data, the patterns of those behaviors, what do they look like? Looking at the child's grades and attendance and their progress toward their goals and objectives, because we've got to look at all this data. And we want input from the parent, we want input from the teacher. All of this information helps us go through this manifestation determination.
Nancy, we've got a couple of questions in that.
Okay, yeah.
One says, I hear IEP team decision a lot. Are there circumstances you see where IEP teams have gone rogue, so to speak, and have written up plans that maybe aren't legally sound, written into the IEP?
So the IEP team is defined in regulations, and so that has to be the parent, administrator, and an administrator has to be someone who supervises the implementation, who also can tell the team if they have the resources to purchase or support that IEP. So usually that's a principal, because only principals can actually conduct performance evaluations to do a plan of improvement if a gen ed teacher or special ed teacher is not implementing an IEP. A gen ed teacher and a special ed teacher, those are definitely members of the IEP. And of course, we want someone to interpret data, oftentimes, because that's part of the least restrictive environment. When you look at 300.116, it talks about the meaning of the evaluation data. So we need someone to interpret the evaluation data to help drive some decision making. So you can't go rogue and write up your own IEP by yourself, or create your own plan by yourself, or do suspensions by yourself. So as a principal, you should, when you go to hand a parent the suspension paperwork, there should be your own district policy about appeals on the backside. Point that out to the parent. I encourage principals to give a copy of the procedural safeguards, which is the parent rights, along with your suspension paperwork. You don't have to at that time, but let the parent know you might want to read over this, because we're required to have an IEP meeting to conduct a manifestation determination, because we're proposing to go over these 10 days. And we want to meet as soon as possible. And because there's a lot that's going to happen, and that's part of, when you look at procedural safeguards, I think it's under 300.504, but someone may need to fact check me. But there's one time a year you have to give procedural safeguards to parent rights, but another one is when you're doing discipline. And that's usually after you've made this determination, this manifestation determination, or you're proposing it. So let's walk through that. That the manifestation determination is done in the IEP meeting for many reasons. And one is because we need to make a determination. Was the behavior caused by or had a direct substantial relationship to the child's disability? And I think that's what's really important. I learned this from Andrea Kunkel, is that it has to have a substantial relationship to the child's disability. For example, a child with other health impairment with ADHD. Maybe it's very explicit within his evaluation data that says the child's impulsive. So if a child got into it with another child in the hallway and said, hey, let's meet after school behind the school and let's fight this out. Well, is that impulsive? Not necessarily, because all day long goes by before we meet outside. That's very planned. Or maybe I plan to post something about somebody. That's very planned. I have to really think about posting. That's not impulsive. I have to really go through these steps to post something. So again, any planning process is not impulsive, but if I'm walking down the hallway and somebody bumps into me by accident, and then I just start punching the daylights out of them, that might be impulsive. So again, you have to kind of weed through a lot of information and make a determination. Is it substantially related to their disability? And sometimes it's a really difficult thing to do and requires a pretty in-depth discussion. And then the next one, a lot of people forget about this one, is was the direct result of this because of the school district's failure to implement the IEP as written? So was the child getting their speech therapy? Was the child getting their counseling? Was the child getting, you have to go back and say, is there any piece of this that was missing? Well, their one-on-one care wasn't there that day, and we didn't have an adult, and nobody was with him. So again, that's our failure to implement the IEP as written. So be careful about that one. So what if we say it's not a manifestation of their disability? So the child had a learning disability in reading, had nothing to do with fighting, and we are going to suspend long-term. So in that case, then you look to see what would be the same suspension that a student or a child without a disability would get for fighting. If it's 3 days for fighting for a typical child, then it should be 3 days for a student with a disability. So you would be looking at that. And so this is what this regulation in 300.530C discusses about the fact that if it's not due to their disability, and we did implement the IEP, so we've said it's not a manifestation, we can suspend them just like a typical child. But you'll see it says except as provided in paragraph D of this section. And so just for your information, paragraph D discusses services. So anytime you're going to go long-term with a student, you have to provide their IEP services, including their general education curriculum assignments. Okay, so make certain that if you're going to go long-term, services have, and that's another reason why you have to have an IEP meeting, so that you can delineate what that's going to look like within the IEP at the beginning of that service and the ending of that service, because it's going to look different since we're going to do a long-term suspension. Okay. Another one is if we say yes, it is determined to be a manifestation, then the IEP team must conduct a functional behavior assessment if we haven't done one already. And then if we have done one, then we just need to review the current one and maybe modify it or revise it if necessary to address the specific behavior incident, because that's part of the requirement in IDA is we need to address this behavior so that it won't occur again. What does that look like? How can we treat this behavior? Because we've got to get in front of this. We've got to be proactive with behavior and prevent these students from reoccurring. So again, if it is determined to be a manifestation, then we have to return the child back to the placement from which the child was removed. And this is where principals do not like this. It's like, this kid had a significant behavior, but because it was, we all agreed that either one, it was due to his or her behavior, or two, we messed up and we didn't implement the IEP as written. And so if that's the case, then we've got to put that kid right back in that class. And that's a tough one, unless the parent in the school agreed to a different type of change in placement as part of modifying either the behavior intervention plan or maybe even the IEP. So sometimes when we have really good, rich discussions with the parent, that helps us a lot in coming to a consensus about what we need to do to help this child. And I keep telling IEP teams, districts, and parents, keep the focus on the child. Don't get into it adult to adult. Focus on what is the need of the child. How can we make the child better? Where can we be proactive to support this child? Because if it is disability related, what's working is not, if we're going to be going over 10 days, it's not working. The behavior intervention plan is not working, or the placement's not working. What can we do differently to help this child get better?
Nancy,
Here. Oh, go ahead.
what about in cases where maybe there was some egregious behavior that necessitated a more than 10-day suspension, right? And they found it to be a manifestation, so they did an FBA. But this is like an isolated behavior. I know it says to implement a BIP. Does the school team really need to put a BIP in place if this isn't something like that's ever occurred with the student before? Maybe it was a weird fluke. Like what what do you say to a situation like that?
So when we look at what it says unless the LA conducted a functional behavior before the behavior that resulted in a change of placement occurred and implemented behavior intervention plan for the child. It doesn't say if it was isolated anywhere that I can read, but isolation sometimes can let us know that the behavior has escalated. Maybe it was a minor behaviors before, and now all of a sudden there's an escalation that's more violent behavior versus what was minor behavior before, or maybe now the child is eloping, which the child never did before. Maybe the child was avoiding tasks and leaving the classroom but never left the building. So that's an escalation. It's an isolated incident, but it's similarly associated with a lower level behavior. To me, it still needs to be addressed because now the kid is, it's like when you try to change behavior, a lot of you who are school psychologists know this. When you implement a behavior intervention plan, you're kind of putting a little bit of some limits on this child. So the child's going to push and push to see if they can break those limits. And so if I can escalate it to a little bit, because you're holding tight until I escalate, and then you break down your structure that you had around the behavior intervention plan. So all of that, those are rich discussions, and I go back to those unique circumstances and case by case. It's hard for me to generalize, but I do want you to know there's nowhere in the statute that talks about isolation. That when I tease everybody about when IDA says must, to me that's really biblical, and I change it to thou shalt do this. So when I see the IEP team must either conduct a functional behavior assessment unless they've already done one, I feel like you have to figure out why has it been minor and now all of a sudden it's escalated to more violent behavior, or it was minor leaving the classroom and now it's escalated to elopement from the building. It's becoming more egregious behavior that needs to be addressed. But that's a question.
No, your clarifications are providing really good context to some of the questions that we get a lot related to these topics. So it's very helpful. Thank you.
You're welcome. And then the next thing that it says is, like we've talked about earlier, that the child has to return. But I always want to know, what does it mean, except as provided in paragraph G? And I'm like, okay, so what does paragraph G says? Because, as a principal, I'm like, I've got to return this kid back to their placement. And it says, except paragraph G. So let's look and see, what is paragraph G? Because that's an exception. So paragraph G is about special circumstances. And when this happens, these special circumstances, there's 3 of them, is when a student has a weapon, drug, or serious bodily injury. When that happens, school personnel may remove the child to an interim alternative educational setting for not more than 45 school days without regard to whether the behavior is determined to be a manifestation of the child's disability. Okay, so it doesn't matter that it's due to my disability. It doesn't matter anything based on that manifestation of the child's disability or implementation. Implementation is important, but it's more about that manifestation of the child's disability. It's more about that regarding a weapon, drug, and serious bodily injury. So let's break these down a little bit, okay? But let's first, people are like, okay, when they say interim alternative educational setting, what does that mean? And okay, let's talk about that first. So again, going back to that Q&A, that Q&A is really good. That was written back in June of 2009. I think they've updated it recently, but that one has some really good language to help you understand the amendments in 2004. So I'd encourage you to go back and read that. But in the appendices that they have there, they define what is an interim alternative educational setting. Because it's really not defined in IDA. They like to throw these terms out in IDA and not define it. I'm like, okay, that would have been nice if you wrote a definition for these terms. But what was defined is as an appropriate setting determined by the team. Again, this is why you must do this manifestation in an IEP team meeting, because there's so much you've got to discuss. And so that setting is determined by the team, the IEP team. Or let's say the parent's not happy with what happened in the manifestation, they can ask for mediation or they can file a due process, and a hearing officer can make those determinations. So these settings can be determined in multiple ways, but it truly should be set up through that IEP team decision. But we want to make certain whatever setting we put this child in for the removal, that they still get their general education curriculum and they still are able to progress toward their annual goals set up in the IEP. Okay. First, let's talk about a weapon, and that's defined as carries a weapon to or possesses a weapon at school or on school premises or to or at a school function. So I love the fact that it says to a school function. So a lot of times when we're going to a football game or baseball game or whatever we're doing, we load everybody up on the school bus and we're driving to a school function, and we find a weapon on the student on the bus going to a school function. Okay. And a school function could be an away game. It could be at the football field, the baseball field. It could be at a basketball court. Even though it's after hours, it's not during the instructional day. It could be at a prom dance that's downtown Oklahoma City or downtown Tulsa or downtown, being Oklahoma. I mean, wherever, but it's a school function program, and a weapon has been brought to this school sponsored function. In school premises, it could be out in the parking lot. I can remember kids saying, but that's in my car and you can't do anything about it. Well, that's on school premises. I'm sorry. And those days are over that guys can bring their hunting rifle with them to school. So make sure that stays at home. All right. Dangerous weapon. The term dangerous weapon means a weapon, device, instrument, material, or substance, animate or inanimate, that is used for or readily capable of causing death or serious bodily injury, except that such term does not include a pocket knife with a blade of less than 2.5 inches in length. Okay, so I joke with a lot of people, there must have been some kind of senator or House of Representative who goes, wait a second, time out, I have a pocket knife, and all good Boy Scout, Girl Scouts carry a pocket knife with them at all times. And so they didn't want that to be considered a weapon. So they wrote that into the statute, the actual law. So it's interesting because that's, when you look at regulations, you look at the letter of the law, and so it says pocket knife. So it has to be defined as a pocket knife with 2.5 inches in length or less. So if that's the case, I can still suspend this kid for a day or 2 days or 3 days. I just cannot remove this child up to 45 school days because it's not considered a weapon. Now let's take a paring knife. A paring knife is less than 2.5 inches. Is a paring knife a pocket knife? The answer is no. Paring knife is not a pocket knife. So can I remove the child for having a paring knife at school for 45 days? Yes, I can. It is not, repeat, not a pocket knife. So again, look at the letter of the law. It says pocket knife. So anything else that could slice of something, that could cause death, that could be considered a weapon. Drugs. Drugs are actually defined in the Controlled Substance Law, which is 21 U.S. Code Section 812. So you can look that up. But we also have it within 530G. Knowingly possesses or uses illegal drugs or sells or solicits the sale of controlled substances. So again, I'm either using, selling, or soliciting to sell a controlled substance while at school, on school premises, or at a school function. So again, selling drugs, it's the same as using drugs. And controlled substances are defined in that. So that's why schools are required to have students who do take controlled substances as part of a treatment, that those are locked up at the office, and someone who's a school person, be it a school nurse or someone that the administration has identified and designated, because that's in our Oklahoma statute, that an administrator can designate and determine who's going to be trained and provide those medications to students during the school day. Some students have to take their medication that's prescribed by a licensed physician that is locked up in the school office somewhere. But if I hold on to my medication and I try to sell my Ritalin or sell, or, I can get in, that is under the definition of drug. And so again, that you can find more information about that, because the question I have a lot is, Nancy, what about marijuana? Because kids will immediately go, hey, I've got my medical marijuana card, you can't suspend me. And I always tell kids, alcohol is legal for me to drink because I'm an adult, but I can't drink alcohol at work. So the same kind of goes for you. You have your legal medical marijuana card, but you can't be smoking marijuana or taking gummies at school. So you can't be doing that during the school day. Now, if a student has a medical marijuana card, they're supposed to take their marijuana within the school day. Please know, as schools, we're still under the Federal Drug Administration guidelines, and that cannot be one of the things that we administer at school. I always tell parents, you're welcome to come check them out, take them home, administer their afternoon medication, whatever they need, and bring them back. So but just know, even if they're legally able to have it, they can't be using or selling marijuana at school. Illegal drugs, again, means control, but it doesn't include those that are legally possessed by the child by a licensed health care professional. So we just talked about that. A lot of people ask me about searches. Can we search students if we suspect that maybe they have a weapon or drug or something on them? And yes, we do have a state statute about that, about searches. But the superintendent, principal, teacher, or security personnel that's a public employee of this within the state of Oklahoma, upon reasonable suspicion. So that's important to know why you even had the suspect of the child. You do have the authority to detain and search any people or property. A lot of kids are like, that locker is my property. No, it's actually the school property, and I may look into that locker. And we also have the ability to look at in the vehicle if I suspect something. So please know that you do have that authority for dangerous weapon, controlled substances, and includes missing or stolen property. I want to just say this out loud. Never do a strip search of a student, ever, ever, ever. Really, the only thing I'd ever have a child take off is just a coat, a jacket, or something like that. Maybe ask them to pull their pockets inside out, maybe take their shoes off. Other than that, nothing else should come off of a child. So you should not be doing their bodily type search that would be considered a strip search. That would not be appropriate. Now here's a really difficult situation called a serious bodily injury. And the definition of serious bodily injury refers back to Title 18 U.S. Code Section 1365 H3, if you want to look it up. And it really is about inflicting bodily injury that's so serious while at school, on school premises, or at a school function. And here's the definition. It means a substantial risk of death. So if a student hits you and you get a bruise, that's not considered serious bodily injury. I know that sounds really awful, that you as a teacher or principal could get hit so hard that you have a bruise, and that is not considered serious bodily injury. There's even a case out there about a broken nose, and the judge ruled that that is not a serious bodily injury. I've had a broken nose, and by golly, I bled a lot. I had big bruised eyes because of it. And I know that that's, to me, would be serious bodily injury, but the judge said, no, Nancy, you're not going to die from a broken nose. It has to be extreme physical pain. And I go back to my nose and go, that was really extremely painful. But that's not what they mean in this definition. Protracted, obvious disfigurement, protracted loss or impairment a function of a bodily member, organ, or mental faculty. So we're going to talk about a case at the end, but anytime you think someone's had a serious bodily injury, send them to the ER, make sure they go to the doctor, because you'll utilize that information from the physician to say, yes, this was a serious bodily injury defined by the physician that had long-lasting impact on this person, either through a bodily function. There's a case out there where a kid wore these steel-toe boots, got the paraprofessional down, kicked them so many times in the stomach, it caused, they had to rush this person to the hospital and they had internal bleeding. That's a serious bodily injury. So that's when you're talking about functions of an organ of a body. So yeah, it's pretty scary.
Nancy, out of curiosity, do you guys get a lot of calls on confusion of the, when I say you guys, the SDE, about confusion as to what constitutes this, the serious bodily injury part, when there's suspensions and manifestations?
Yeah, because they think hitting a teacher, anybody hitting any teacher should be serious bodily injury, and we should automatically remove them for 45 days. And when I tell them it's got to be a substantial risk of death, they are not happy to hear that, because I said you could still suspend a student for hitting a teacher and should, but to remove them up to 45 school days is a big no. It doesn't fall under this special circumstance.
And then same for like peers, if they had a fight or hit a peer, right? Like same,
Correct.
they technically could, if it met this criteria, have inflicted serious bodily injury on a peer, but it still has to meet this criteria to be considered SBI, which
it has to meet this criteria for anybody, be it another student, be it a teacher, be it someone who just walked in the building, like a visitor, and got in the middle of something and this kid attacked this visitor. It's still the same. If it caused serious bodily injury, the student could be removed up to 45 school days.
Okay, thank you.
Yeah, for sure. So the law does talk about we must notify the parent of the decision. So on the date on which the decision is made, that's really important, to make the removal that constitute a change in placement, a child with a disability because of a violation of a code of conduct, the LEA must notify the parents that the decision that they've made, that they're going to do a long-term suspension, either removal for special circumstance or long-term suspension, and provide the parents with procedural safeguards. So after this meeting, when we do our manifestation determination, we must provide the parent a written notice saying we're proposing to initiate long-term suspension, or we're going to propose a removal due to a special circumstance up to 45 school days, whether it's due to their disability or not. So you've got to put all this in writing. I always say people misunderstand because the law talks about prior written notice. It also talks about it just as notice, and it also talks about it as written notice. But that word prior really messes people up. Some people think you need to send that before the meeting. Don't do that. That's predetermination. The only thing that should go out before a meeting is an invitation meeting. The purpose of the meeting, who's going to be there, the time and date and location, that's the invitation meeting. The prior written notice means we've had this rich discussion first, and now I'm going to place in writing that beautiful, rich discussion that we just had, because we went over a lot. Remember, to do a manifestation, what do we have to do? We have to discuss relevant information about the behavior incident in order to make a manifestation determination. And if we are going to do any type of suspension, we've got to do some services. So we've got to amend the IEP, especially if we're going to do long-term. And then we've got to give all this stuff in writing. We've got to talk about the options we considered, reasons why it wasn't appropriate, and then outline everything that we're going to do in that written. I tell people that's my all-time favorite form because I can't remember what I did yesterday, much less if the parent, when they file a state complaint or due process, there's a time limit. And in a due process, they can go back 2 years. And I can't remember that far back, but the written notice is going to be rich with information that describes what happened in that meeting. But under 300.504, you also have to give them a copy of their parent rights, which means I have a right to mediation. I have a right to file a state complaint. I have a right to file a due process regarding this long-term suspension that the district has made a determination to do. The same goes for you as a district. You have a right to file a due process with a hearing officer to say, you know what? We know the special circumstance only allows up to 45 school days, but we want to prove that this child is extremely dangerous. Not only was it serious bodily injury, but we think this child, it will occur again. And you can go to a hearing officer to ask for an extension of that 45 school days. So again, all of these are on a case-by-case basis, and you have to have a significant data and proof before doing those kinds of things, because a hearing officer is going to require that type of documentation. So documentation is so important in all of these determination and decisions. So again, procedural safeguards, what are those? A lot of people call them parent rights, but they are truly procedural safeguards, which means I as a parent or I as an adult student have a right to mediation, state complaint, or a due process complaint. And so in 300.504C, it talks about the special circumstances of when that occurs. And, you know, you have to, again, provide prior written notice, opportunity to present and resolve that complaint and through a due process complaint or state complaint, the availability of mediation, and then procedures for students who are subject to a placement in interim alternative education setting, because the parent may not be okay with what you determine as the interim alternative education setting. There might be a disagreement about that. So let's go back, and I'm taking too long. This is a hard one to get through, and I'm going to go over my time, so I apologize up front. Services during the removal, again, this is a team determination and discussion about what that's going to look like. So we need to make sure that the child continues in those general education curriculum assignments, although in another setting, and make progress toward their IP goals. And we want to make sure that a child who's removed from their child's current placement, we must receive an appropriate functional behavior assessment, behavioral intervention services, and modifications that are designed to address the behavior violation so it doesn't reoccur. That's really important.
Hey, Nancy, I want to tell you, we're okay. We allot that 1 to 1:30 time for questions, and we've been doing questions throughout. So I don't want you to feel like you have to finish in just a couple minutes. So we're good.
All right, great. Perfect. So again, talking about services, the public agency is only required to provide services during periods of removal to a child with a disability who's been removed from his or her current placement for 10 school days or more. But if it's less, then you do not have to provide those services if it provides services to children without disabilities similarly removed. So let me say that again. If you're going to be 10 days or less, you're not required to provide the services. If you're going to go over those 10 days, you are required to provide services. But the law does say unless services are provided to children without disabilities. So that's why I want you to look at Oklahoma statute, section 24-101.3D. That applies to all students who are suspended out of school more than 5 days. So starting on day 6, you must be providing services for children on IP. So just know that you would be in violation of Oklahoma statute if you are not providing services for children with disabilities as we would for students without disabilities starting on day 6. But the 10-day rule is the manifestation requirement. So this is just for your information if you want to know what it meant. A lot of parents, I've had this call, well, what about PE and what about all this? How are they going to get PE? Well, the law talks about providing only the core units, and core units are described as English, math, science, and social studies, and art unit was an Oklahoma statute. I know this law is up for amendment this spring, so I don't know what that will look like. But currently, this is what the statute is at this time. So when they start saying, what about PE? Say, well, the statute just says that we must provide, support for your child to continue in those core subject areas. And this is for grades kindergarten through 8 and for high school grades 9 through 12. And again, services during the removal after the child with disability has been removed from their current placement for 10 school days in the same school year. If the current removal is not more than 10 consecutive school days and is not a change in placement, then in consultation with at least one of your teachers, determine the extent of what the services would be needed. So when you're looking at day 6, just have consultation with the teacher. What would this look like? And so being teacher of record, if I'm the special ed teacher, I'm teacher of record, and I'm in a high school and this kid has multiple teachers, it's really my responsibility as the teacher of record to consult with the English teacher and the math teacher and the science teacher and the social studies and say, okay, it's day 6, and so now we need to get some services out to this kiddo. Tell me what we need to do to keep him or her up to date in their assignments, kind of thing. It goes on to say, if the removal is a change in placement, meaning more than 10 days, the child's IEP determines those appropriate services. Well, again, so I say this probably 100 times today, you have to have an IEP meeting. Don't try to do this alone as a principal. The services are required in paragraph D1, 3, 4, and 5 may be provided in an interim alternative educational setting. So does an interim alternative education require an IEP team meeting, and why? The answer is yes. So yeah, the services, we have to make those determinations through that IEP team, because that's what it says in 300.531, determination of the setting. It is the child's IEP team who determines the interim alternative educational setting for the services. So again, don't try to do this stuff alone. Don't try to do it by just you and the parent as a special ed teacher. It is a true team meeting. And it's important that when you do a team meeting, we can invite additional people to this meeting. You know, it may not just be the principal, special ed, gen ed teacher and the parent. You might be inviting additional people, maybe a school psychologist, a behavior interventionist. It may be other people, depending on the special circumstances. It may be a speech pathologist that needs to be involved. Maybe this child has, you know, severe pragmatic language, meaning that they struggle when people imply that they don't understand, they don't read between the lines, and so the behaviors are because of that. You know, it's amazing until you pull everybody to the table to discuss, hey, this is really disability related. We don't know to make these decisions, as well as looking at where can we place this child, because some kids cannot learn, even if we say, because the law says you can put this can be another setting. So let's say we put him at home on a computer. What if the kid can't make progress? So we may have to schedule a time for a bus to go pick this kid up, bring him to a different building, maybe not the high school, but maybe the administration building, and have somebody meet him there to provide direct instruction. In some larger districts, they have more options, so they may have an alternative school. It's a whole building, and they may have a couple of classes in a hallway where they have teachers that provide that direct instruction in person, because these kids who are suspended long-term cannot make progress independently on their home, at home, or online. So remember, the law says any lack of progress, we have to meet and make a change again. Maybe we said you're going home, you're going to be virtual for however many days long-term. If the kid's not making progress, because that's my responsibility as teacher of record to keep track, is this kid making progress in their general education curriculum and their IEP goals? So if that's not working, we've got to meet and modify the interim alternative education setting. That still applies, okay? How many MDRs are required each school year? I get that question a lot. So once the student has been suspended long-term, meaning more than 10 consecutive or more 10 that add up, that are cumulative. Once we do that one MDR, and then the kid comes back and they do another behavior incident within that same school year, we've got to do another manifestation determination review, okay? So you will continue to do more of them if the kid continues to have behavior incidents that rise to a level of suspension. So hence, do you see why the law says you must have in place something about addressing the behavior so it doesn't keep reoccurring?
And Natalie, to clarify on this one, because I know that it's a it can be a hardship on school IEP teams, but it's there to protect the student. So if a student's already hit their 10 days, right, where we've already had to have that first MDR, their next suspension is say for 3 days, another MDR, right? Their next suspension, they get suspended again for just 1 day, another MDR, correct?
Correct.
Once they've had that first one, any removal requires an MDR related. Yeah.
Yes.
Yeah.
Yes. And I'm so sorry, but it's when it rises to that level of removal, of suspension, then yes, another manifestation is required and so forth and so forth, as long as it's within that school year. When you start another school year, it starts over to 0 when you're counting your 10 days, okay? But yes, it is there as a protection, and it is really there to say, we're not addressing the behavior. This behavior plan is not working, this placement's not working. It really makes you stop and think. And that's the whole process, is really to be a problem-solving model. And it forces us to do that by having these laws. So it's a good thing. I know people hate paperwork, but the paperwork drives us to problem solve. So child fine. How does child fine mesh with discipline? Well, good question. So looking at child fine, and by the way, I love just making up this little story, is that long, long ago, when I was in school, children with disabilities did not go to school. So you can tell how very old I am. So prior to 1975, children with disabilities that had significant disabilities did not come to school. So once that law was written, there was an obligation under the LEA to go out and find these children and basically, and I'm exaggerating, knocking on the door and say, Mom, your child with a severe disability now can come to school. Even though your child has a trach, a ventilator, they can come to school. Even though your child has significant cognitive disability, they can come to school. So that's why they called it child fine, and it was remained as child fine. But really it is your LEA or school district's obligation to find all children out in your community who have disabilities or suspected disabilities that reside in your area. And that's our responsibility as a state agency too. So whether they're homeless children, whether they're a ward of the state, meaning that, they've been removed from their biological parents and now they're with a foster family that lives in your district, or maybe they're currently in a temporary shelter and they last say, I lived in Bing and now I'm in a shelter. Well, Bing's still responsible for me if I want to go back there. So see how broad this can be. So don't just think it's just my little boundary. Think about all children and those children that are attending private school. So that's another whole discussion. I won't get into it because it gets really complicated, but even children in private school, be it the resident or where the private school is located, have a child fine responsibility. So, and again, regardless of the severity, and that's what was really important way back in 1975, no matter how severe your child's disability is, they can come to public school. And that was pretty eye-opening back in 1975. So it is our obligation as school districts to identify, locate, and evaluate these children. So child fine is that initial evaluation piece too, okay? So, but the law also talks about other children in child fine are those kids who are suspected of a disability, who might be in need of special education, even though they are advancing from grade to grade. That's a key. And no doubt we have highly mobile children who are migrant children too. But I really want to focus on even though they're advancing from grade to grade. So think about that as we go through the next few things, okay? So for an initial evaluation, if a request is made for an evaluation of a child during the time period in which the child is subject to disciplinary suspension or removal, the evaluation must be conducted in an expedited manner. I remember when we put this out in the policy and procedures, we got a public comment saying, why are you putting expedited manner in your policy and procedures? They didn't realize we were quoting the federal regulation. And that's right. You have to drop everything. And this kid needs to be number one in getting evaluated, because why? We need to know, is this child a child with a disability? And so pending the results of the evaluation, the student will remain in the educational placement determined by the LEA officials. So you as a principal can make that determination of where this child will be until such time the evaluation is completed. So let's say that the child didn't qualify. We did all the testing, sat down, we're doing our meetings, the child did not, repeat, did not qualify. So if the determination is they're not eligible, then the student is now considered a student without a disability, they're non-disabled, and now they're going to have the same disciplinary actions any other kid would get, okay? But if we do determine that they're eligible, then what must we do? Well, this is an initial, we're going to have to do an IEP meeting anyway, right? But then what do we have to do? We have to conduct a manifestation determination. So how do you do that when the child's never been on an IEP? Because, well, then you're like, okay, well, it's really hard to suspend a kid beyond 10 days because of the fact we weren't serving this child and meeting their unique needs. And so really we need to put this child in this placement and try this instead of kicking them completely out of school, right? So it's definitely something for the team to discuss. Again, everything is based on unique circumstances, so don't just say all means all.
Nancy, someone has asked in the Q&A, is the term expedited defined? Is it time certain, or is it sort of like our reasonable time frame that we have a lot as well?
You know, expedited is not defined that I'm aware of. I've looked, I can't find it in statute or in the regulations, but expedited to me means as soon as possible. Like, you know, that is a #1 priority. Even for initials, you still have 45 school days, but you still want to do as quickly as possible. 45 school days is approximately, what, 9 weeks? That's a long time, especially because this child is up for removal. And so therefore, I want to do it sooner than that because this child may be, and please know we don't want to delay this initial evaluation because then that could morph into some other issues regarding compensatory services because this child really did have a disability and we didn't know about it. So I don't know if I'm kind of getting ahead of myself, but let's go back to that pattern of behavior. If there has been a pattern of behavior, that's a big red flag that this might be a child that has a disability and that we never did anything about it. If we had some behavioral data and interventions that were working, great, but if we had interventions that were not working and we were trying different things, still not working, maybe this is a child we should have been referring for an initial evaluation. So again, pattern of behaviors, very important. And if we start pulling that data that the principal has all these findings and suspensions, it could possibly be a child. That's why child find is so intertwined and wrapped because red flags could be going off with patterns of behavior.
Thank you.
So if the behavior is caused by or has a substantial relationship to the student's disability, the disciplinary action must be set aside, okay? And the student must be provided appropriate educational service in the least restrictive environment. The IEP team should also conduct an FBA and a BIP to address these behavioral concerns. So if it is not a manifestation, if the behavior is not a manifestation, after we've determined eligibility, then the student is subject to disciplinary measurements. So for example, it was found that I had a learning disability in reading and I was fighting. So I may get that suspension just like a typical student. So again, going back to the fact that once I'm determined eligible, if it is a manifestation, then you can't suspend me. And going forward, if it's not a manifestation, that's when I say everything depends because it depends on the category disability. It depends on the type of relevant information surrounding that disability, those special circumstances, those educational needs. There's so many factors that the team has to consider as part of the manifestation. So if it's not, we can do the suspension, but again, educational services still must be provided for this child so that they make progress in that curriculum or the general education classroom and working toward their goals of the IEP. All right, I'm getting closer to the end and I have a couple scenarios that I want to kind of wrap up. So LRE is a publication, and because it is copyright, they told me I could use the information as part of the training, but I couldn't show you everything. So I'm going to read it to you, but I would encourage you, if you are a director out there, this is a great way to spend some of your money is to get involved with the LRE publications. They're outstanding, and they oftentimes summarize court cases. But here's a court case out of New Jersey. where an upper elementary student with other health impairment, and this child had significant anxiety, depression, and ADHD. His parents continued to talk to the school district about meltdowns that were happening at home and struggle with doing homework at home. The student's behavior were somewhat minor, as going back to our example earlier, he was leaving the classroom quite a bit, but this time he ran out of the building, he eloped. And of course, school personnel went running after them. They had to do a restraint because he was going into a very busy street. They had to do a 2-person restraint all the way back into the building. They actually had to seclude him because he was out of control. And they called the mother, told the mother to take him home. And do you know what also they told the parent? You need to go have him have a psychological evaluation, a mental health evaluation, and you may not bring him back until you bring us that mental health evaluation. And so the district placed him on home instruction. And he did not get cleared by the psychologist to return to school for more than 60 days because it took Mom forever to even get an appointment to see this psychologist. And so the district asserted that it did not consider this a removal or suspension because it was just an isolated incident of an elopement. This is the first time he ever ran out of the building. He never ran out of the building before. And they decided not to do a manifestation determination review because, again, it was an isolated incident. He never had a pattern of this behavior before. And they told the mom he needed to go get a psychological evaluation before he came back. And it was basically, their fault. They couldn't get this done in time to bring back. And so we didn't consider it a removal. So we didn't need to do MDR, right? But the good thing is they did conduct an IEP meeting within 10 days after the elopement, but they made no changes to the IEP because why? It was an isolated incident of him running out of the building. Instead, the LEA developed a proposal that we talk about his transition to middle school because he's upper elementary. They decided to talk about his transition to middle school for next year. And that's really all they addressed in the IEP. And Mom brought in an outside evaluation about autism, and they rejected the parents' outside information and diagnosis. They failed to develop a reentry plan for this child. And they decided that the BIP or safety plan weren't required because, again, it was isolated incident. The child required a transition to virtual instruction during these 60 days. And they struggled to get him online. And so he was counted chronically absent because he wouldn't log in. And so basically this kid just shut down and quit turning on the computer, refused to get online, and began to regress in both general education assignments and his IEP goals. Therefore, the parents placed their child in a special education private school that was a residential setting outside of the district boundaries. So tell me, did this district deny this child FAPE when the district placed him on home instruction on virtual instruction? Yes or no?
One guest has typed in the Q&A, yes.
Yes, it's a big yes, right?
Yes.
To me, this is kind of a no-brainer, but oh my gosh. Yes, they denied this poor child FAPE because why? Multiple reasons why. One, you can never tell a child with a disability, go get a psychological evaluation. You cannot come back until such time. You can't do that. Don't do that. Okay. We know this child has issues. This child's behaviors have been in place a long time, but he just escalated and eloped. Just because it was a single incident, it still was related to him leaving the classroom, even though this time he left the building. It was an avoidance task that was related to the functional behavior assessment and the behavior intervention plan. He just escalated it to a crazier point, and he did go emotionally out of control. He had a major meltdown. And the parents were telling the district all along, this is happening at home, this is happening. He was keeping it together somewhat at school. This time, the cap came off the bottle. And so they did have an IP team meeting, but they did not conduct a functional, I mean, they didn't review and revise the IP. They didn't change the placement. They did not even discuss. I mean, they thought they were just, they didn't even consider it a suspension or removal. And all that was not okay. So the hearing officers found that they did deny FAPE by placing him on virtual. He did not make any progress. They never meant to look at that. And so the district must perform a manifestation determination within 10 days of a change in placement of a child with a disability because of a violation of a code of conduct. And so, yeah, they ended up having to pay for that private school placement.
I was just going to ask that if they awarded compensatory ed and or payment for private school placement in that case. Okay.
Yes, and that was extremely costly to that district.
I'm sure it was.
Here's another one. This one's out of Pennsylvania. Again, this is an elementary age student who had a learning disability, but also had other health impairments due to ADHD. But this child started exhibiting violent behaviors. And so I find that interesting because the learning disability and other health impairment for ADHD, but apparently they felt like the violent behaviors did not rise to any type of mental health condition. But they did have a behavior intervention plan in place. And so when they got to the 10 days, they conducted a manifestation determination and determined that it was related to the child's disability of impulsivity. And so they revised the behavior plan. They did a bunch of more changes of his placement. So they're really trying to be proactive about this kid's behaviors. But on occasion, when he would escalate, part of the behavior plan was to take him out of the regular classroom because he was being disruptive. So whenever a student with a disability is impacting the learning of others, there can be some changes. And that was actually written into the behavior intervention plan. So they removed him and brought him down to his counselor. But while he was down in the counselor's room, he was out of control. He got up on the desk and he began to beat the tar out of this teacher. So badly that she had to be sent to the doctor. And this was a close fist, multiple punches to the head. And the counselor went for medical treatment. She was diagnosed with a concussion. She experienced fogginess, confusion, pain, and difficulty speaking for the next 20 days. So the district concluded that the student caused the counselor serious bodily injury, and the district removed the student to an interim alternative educational setting for 45 school days. The parent filed an expedited due process hearing, alleging that the removal was inappropriate. So what do you think? Did the district improperly remove this child who had a learning disability and other health impairment? And the key is, did the district improperly remove? Because that's what the parent filed the due process on. The answer is no, they did not improperly remove. It was considered a serious bodily injury. Long time ago, they used to think that concussions were not considered serious bodily injury. Now, over time, more and more long-term research is showing there is significant damage to the brain with concussions. And she did experience long-term effects. She went 20 days, it said, struggling to speak. So it impacted her bodily function of her brain. And so again, it's important to send people to the doctor or ER and get information from the doctor to define, is this a serious bodily injury? And that's one of the only tips. So we have a regular due process and an expedited due process. And this is one of the cases that the parent can file to say, I need a fast answer. And that's when the hearing officer can be pulled in to look at all the data to make those determinations. So, all right. So, additional questions?
I am not seeing any in Q&A or chat. We got lots and lots of questions and discussions throughout, so I appreciate your time, Nancy. The breadth and depth of your knowledge is so helpful to have. Your expertise and the discussions and your clarifications are incredibly insightful. I think it gives teams, school teams and parents some really good understanding of these topics and the complexity of special education.
It's very complex.
Yes. So thank you so much, Nancy. We really appreciate you guys attending as well. Appreciate you and your time, Nancy. And we have another Wisdom Wednesday webinar coming up in March, on March 12th, where we will have Andrea Kunkel with the Oklahoma Directors of Special Services and Ellen Kimbrell with Oklahoma Parent Center. They'll be talking about parent requests and school district obligations. So consider joining us in March as well. And Nancy, again, thank you so much for your time and expertise.
You're welcome. Have a great day, everybody.
Thank you.
Bye-bye.